Segment 5, Polarized and Opaque. Adam Liptak, this past autumn in the New York Times, quote, "In decisions on questions great and small, the Supreme Court under Chief Justice John Roberts often provides only limited or ambiguous guidance to lower courts." Close quote. I'll start with John again.
Sorry, Richard.
You've already suggested what you're. Go ahead.
Well, this is actually a product, I think, of the way Justice Roberts decides cases and the way he wants to decide cases. You remember at the time he was a great fan during his hearings and before and after of this kind of common law method where you decide cases, incrementally. You try to strive for unanimity, decide things on the smallest grounds
Chief Justice
possible.
Roberts in 2006, quote, "The more cautious approach, the approach that can get the most justices to sign on to it, is the preferred approach."
Wrong.
Yeah, I tend to agree with the critics that the court should announce clear rules because they're really the head of a system. They're not just deciding the facts of a case. That's a job for hundreds of other judges. What would be better is they announce clear, definitive rules.
They should prefer clarity over consensus.
I think there's also...
Whatever, the clearest possible decision that gets you to 5 votes is the one you should go for.
No, I don't think that. I mean, remember, when you're trying to say that there's another problem with this sort of incrementalism. First of all, it's a misrepresentation of the way in which the common law system works. Yep. There are many famous common law decisions which have very powerful articulated rules in them which give immense guidance. You have a rule which does or does not require privity in product liability cases. Audiences may not know what that means, but it means in effect...
I barely know what that means.
It means that it means that a consumer cannot sue a manufacturer.
I don't want to know what it means.
So you get, some of them are clear and bad, some of them are clear and good, but many of them are just clear. So there's no sort of standard level of granularity at common law, which means that everything is small and narrow. Some of these things are big and some of them are small. The assumption of risk defenses in industrial accidents was a big rule.
But the reason you have a Supreme Court at all
is to decide rules.
Is to decide broad rules.
So what does Justice Roberts do? When Justice Roberts says the more cautious approach, what he's saying in effect is, I just got to this court, calm down, folks, I'm not going to be a bomb thrower. I'm going to try to build consensus.
I think he did it for political reasons.
No, I don't believe that.
He thought the court's legitimacy was in doubt. He thought that a lot of attacks on the court, a lot of questioning of decisions because of the polarized voting press. I think it's mistaken, but I think that's what he thought.
No, I don't believe that.
And that's why I want to bring the court
I think
together.
he's actually less political. Justice Roberts was a litigator before he went on this circuit court. And one of the principles that you have as a litigator is the same one we talked about in the first segment. You want to shoot your target with a bullet. You don't want to have to bring down the entire structure to bring your case. So whenever he argued before the Supreme Court, he tried to get narrow ground so that his client would win, and he didn't worry much about the law. But that's your job as a lawyer. It's not your job.
Professional. Yeah, but
it's not.
The funny thing is, he's the exact opposite of the way Scalia views the law. Scalia has this famous article called "The Rule of Law is a Law of Rules." He thinks the job of courts. I very much agree with this view of the Supreme Court's function. Announce clear, simple rules. Actually, you have a famous book called "Simple Rules
for a Complex World."
Clear, simple rules, and let the lower court judges. I think this book is much better and worth buying, by the way. But
what?
Not my book.
Oh, well, wait a second. We have to
stop this. Stop this.
Well, mine's 5 times as long, so it's 5 times more wisdom. So
no. It just means that you're garrulous.
No, but I think the point. Richard just called me garrulous.
Richard called you garrulous. We'll embroider that moment on a cushion for you, John.
Well, I think that's the point. The Supreme Court is a unique institution. It sits at the top of the entire judicial system. Let the lower court judges make those kind of granular decisions Richard's talking about. The court has to announce rules so the whole system can function. If you're always in doubt, in fact, it's actually good for people like Roberts. It's always unclear. There's just going to be a lot of litigation all the time.
Mind you, by the way, the point about the Tubin thing is the obscurity is not associated with the 5-4 splits. Sometimes when they have unanimous decisions, they write these obscure decisions. Right. I mean, and in fact, sometimes you really do want to have a clear rule. It's better to...
Adam Liptak, slightly different point, writing again in September this time. Yeah. On, quote, political polarization on the Supreme Court. These days, says Adam Liptak of the New York Times, the more conservative justices are much more likely than were their predecessors to hire clerks who work for judges appointed by Republicans.
That's true.
And the more liberal justices are more likely than in the past to hire from judges appointed by Democrats. Liptak notes
he's right
that all 84 of the clerks Justice Thomas has hired since joining the court, first worked for judges appointed by Republicans. And since I'm looking at one of those, what do you make of that, John?
I'm trying to...
Who clerked for Judge Silberman and then Justice Clarence Thomas.
I'm trying to remember if that's true. Yes, I am one of them. I think that's true. I mean, I don't know.
I'm sure it's true.
Let's stipulate it. What you say? You get to use
by the way, I regard.
So what does that say? Something good or bad?
I actually think it's not a great thing, but I don't think it's a product of the justices. I think the constitutional law has become polarized. And it's become much more conservative versus liberal, I think, than it used to be. And I think the Supreme Court has made this even worse.
Used to be when? You're talking about 5 decades? You take the historical
You have
view
to
like
go.
Richard?
Let me give you.
The 50s, I think.
Let me give you an illustration.
Let me say one more thing. I think the Supreme Court has made it worse by inserting itself into cases like abortion, gay marriage, and so on.
Right.
That invites the politicization of the court and constitutional
Let me give you an
law.
illustration. 1956, I remember this as a kid reading, or 57, Potter Stewart gets nominated. There is a story on an 8-column New York Times in the lower left corner, which is about 6 inches high, right? By the time you get to Scalia's nomination...
Only you would have a visual memory of the front page of the New York Times in 1956, but go ahead.
Well, it was later than that. But then by the time you get to the Scalia nomination in 1986, it's a banner headline.
It's a huge story.
So,
right.
I mean, you're seeing the stakes there because judges have really taken a somewhat different role of their own view. I think, however, that I do not like this situation of only taking clerks who agree with you. I think you have to, as a justice, put yourself at risk. And maybe if you've got 4, you take 3 who are sympathetic to you and 1 who is not.
Which, by the way, is what Scalia does. Liptak writes. Yeah. Scalia always has, he takes 4 at a time. 3 tend to be conservative, but he always wants a liberal.
Yeah, and that, to me, that's perfectly okay, because what it does, in effect, is it makes you a better judge if, in fact, you have in your chambers to answer what is likely to be the strongest arguments on the other side.
And if you could offer 1, in your case 2, sentences of advice to the Chief Justice of the United States, John Roberts, what would you say?
God, you go ahead first. You give your first 2 sentences.
My view about this is I would think that the criticisms that we made is you would try to basically think in your role as a Chief Justice as sharply distinguished from your role as a litigator in this rules debate. And I also think, in effect, that one has to pay at the Supreme Court level more attention to theory and less attention to particular facts in trying to organize these cases. And that third, the theories that you want to try to refer to are those of classical liberalism, not those of modern progressivism.
I would say try to return constitutional law back to the original understanding of the Constitution, and don't worry so much, as he does, about precedent and what other Supreme Courts and what other justices have said.
You're a Justice Thomas man.
Yeah, I would say return back to what the people originally wrote and ratified when they adopted the Constitution, and not cut back at the drift.
I am agonized to say so, but we're out of time. Richard Epstein, John Yoo. The bet has now been memorialized on tape. Richard Epstein, John Yoo, thank you.
Okay.
Thanks.
For Uncommon Knowledge, I'm Peter Robinson. Thanks for joining us.